So we've got a number of matters before the court today, and it's fairly clear that the parties did not heed this court's encouragement to stand down, quit all the nonsense, quit the fighting, quit the harassment, quit the videoing, and just try and be decent neighbors. I guess I was overly optimistic that you guys could be decent people. And I'm talking to both sides. This is no way to engage with each other. If you are really looking for years worth of litigation, it's absolutely sad that you're putting yourselves in that position, that you're choosing to be miserable. You're choosing to fight over everything. The court has to take up whatever stuff that you file. It's an inordinate amount of filings. It's an inordinate amount of back and forth, bickering, he said, she said. Not a great use of this court's time and resources to deal with the parties here when there's no reason for the continued animosity back and forth. The one legitimate thing that is before the court, they described the easement, and it seems like it boils down to the west half, and it should be the west quarter. That's what Ms. Rowan is requesting, and it sounds like, Mr. Dyer, that you agree that the court messed that up and it should be the west quarter.
Yes.
Okay. Rest of the filings deal with motion for protective order regarding some discovery things. Ms. Nemchek, seems to me that discovery had already closed on this case. Is that right?
He pulled that scheduling order on that. Wasn't able to view on the computer earlier, but let me take a look. It should have been, discovery should have been completed a while ago at the pre-trial. Scheduling order was issued July 26th of 2024 with 150 days of discovery. So discovery should have closed December 23rd of last year.
Means, Mr. Dyer, is that once the discovery closes, that's the end of the fact gathering part of the case in terms of being able to make requests for certain proof to support any claim that you have. Different sort of posture if the request was made while discovery was still open and there was no from the opposing party didn't respond. Typically, the way that would come to the court would be on a motion to compel discovery. So,
I'm asking for things specifically that took place after your judgment, Your Honor. On April 17th of this year, she created a Facebook. In that group, she talked specifically about me and Dawn about this court case.
I've read that. But that's all new stuff that could be new causes of action. Okay, so when you file a complaint, you say this is what my grievances are up until the date that I filed this. So otherwise, there would be no end ever. It would just be a constant, more allegations, more answers. So whatever happened after that is not part of this case.
Okay, so that would be covered in my amended counter complaint then that I have filed. Your Honor, the day we left court, they started blocking and restricting the easement again. Every time we go down it, we're getting yells, taunts. She's being called a whore, a baby killer. This has gone on since the day after court, Your Honor.
If that's true, that's not part of this case. It could be, if you're doing things that are in violation of my opinion and order, that's one thing. That's subject to potential contempt. If it's new bad actions or activities that aren't originally complained of, that would be a new case, because we just can't keep amending Because in the case, it's no finality.
That I understand, Your Honor, and if they would have ever ceased, we wouldn't be amending. If when we walked out of court on March 31st, they had not started doing this again on April 1st, we would have no need to amend our case. That's why I asked Your Honor for sanctions in the motion for I'm sorry, Your Honor, for her motion for clarification, because she specifically stated in this court that the easement was for the two properties behind her. And then as soon as we left court, she changed it to the easement was only for the one property behind her.
I don't care because I already issued an opinion on the easement. May even make things worse. If that's what you guys brought to court for me to do, and that's what I'll decide. Because it's clear that both parties just want to fight.
Your Honor, I would prefer to just not. I really would. But I can't leave my house without screams and taunts coming from these people. I can't leave my house without driving by the easement. We have not used the easement in over a month that you told us we could because of the things that happen when we do.
Here's to be paid in full. So
I'm sorry.
I don't know who's told you what, but they paid you.
The postal delivery man stated that it was a $31-some charge that I needed to come up with. I asked him 3 times.
If that was the case, all he would have said was just sign for it.
I asked him 3 times. He knocked on my door. If it didn't need to be signed for, he would have left it in the mailbox.
The original complaint was that they sent it to you with postage due. They did. They paid for it. So there you go. Problem solved. Typically, I would send parties to mediation, but I don't think that's going to work with you guys. So we're just going to have a trial, and we'll go from there. So, is a day enough? 2 days? How much time of the court's time are you going to waste with this trial?
Everything that I'm going to present to this court will be shown with proof, date, times, and witnesses.
So how much time?
A day.
So we'll send out a notice for a 2-day trial.
Your Honor, we have a motion in front of you on October 14th. And that is for the amended counterclaim that we have filed because of the things that have happened since court.
So I'll move on it then, but I'm just telling you right now, I doubt I'm going to allow that because nobody can hit a moving target. So at some point, things close. These are the allegations that we're dealing with because where you guys go, and I'm saying you guys, I'm saying both you guys, where you guys go, every day, every week, there could be more allegations raised and more things. And no, so we're just dealing with what we originally pledged. That's it.
So in other words, Your Honor, they can continue to do what they're doing. She can go home and put more people into her Facebook group where she accuses me of going after her 12-year-old daughter, where she lies directly about what's going on in this courtroom, which has 300 people in it now.
Well, the fact that you phrase that question that way means that what I'm telling you, you're not even understanding. I'm saying it's not part of this case. I'm not saying she can or can't do anything. It's not part of what's been filed so far.
And that's why I asked for the amended counterclaim, Your Honor.
No, we're dealing with what was originally pled. Either you can prove your stuff, or they can prove theirs or not. What was originally pled. That's it.
So I need to file a new claim about what's happened since?
That would be the way to bring it before the court. It's a whole new case. And again, you're making my point that there's no end to this.
Your Honor, we haven't been the ones continuing it. I didn't block the easement as you instructed us not to.
So we'll see. We'll see. That's what the trial's about. So it'll be a 2-day trial. That's all for today.